Good morning, Commissioners. The topic that this team will be dealing with in its submissions relates to rationale, and the submissions will be presented through reading the written submissions into the record, and where not necessary, some of the paragraphs will be skipped, but we will indicate to the Commission as to which areas we will skip. And also, the Commissioners will indicate to us in cases where they are of the view that any portion of the submissions is already on record, or that is something that is already in the, which is, it is something that is already common cause. So I now beg leave to commence to record the submissions. Chair, may I proceed? The introduction. On the 4th of November 2011, the President of the Republic of South Africa, Mr. Jacob Gedlehlekisa Zuma, appointed the Arms Procurement Commission in terms of Section 84(2)(f) of the Constitution of the Republic of South Africa Act.
I'm sorry, Ms. Ramachara.
Yes,
think,
Chair.
you know, paragraph 1 is common cause. Many of the submissions contain that paragraph. Same applies to paragraph 2. Maybe if you can start with paragraph 3, which is on page 2.
Thank you, Chair. Then I proceed to read the contents of the written submissions into the record, commencing at page 2, paragraph 3. In these submissions, we intend dealing with the term of reference 1.1 in respect of the rationale for the SDPP. In its investigation of the term of reference on the rationale of the SDPP, the Commission received various documents from relevant state departments, led oral evidence from former and current officials of the relevant state departments and interested parties. In particular, oral evidence was led from the current and former officials of the Department of Defense, the Armaments Corporation, the Department of Treasury, and the Department of Trade and Industry, and the former cabinet ministers who were in the Ministers' Committee appointed to consider the recommendations from the relevant committees evaluating the SDPPs. In preparation of these submissions, we have considered the relevant documents submitted to the Commission as formal submissions in response to the invitation to make submissions. Documents submitted by State Departments and the evidence of witnesses who testified to the Commission, noting that the terms of reference require the Commission to consider the Constitution, relevant legislation, policies and guidelines in its investigation. We also considered these instruments. During the opening address by the evidence leaders on the eve of the commencement of the hearings at the Commission, the evidence leaders undertook to present evidence on the rationale to deal with the following. And that just outlines the headings of the topics that the evidence leaders took the Commission through during the opening session. I now proceed to paragraph 6, which is on page 4. In these submissions, we intend dealing with the term of reference relating to the rationale in the following terms, which in our view will encapsulate the issues set out in paragraph 5 above. A, whether the decision to acquire the relevant arms was justifiable. B, whether the acquisition was duly authorized. C, whether the decision to change the acquisition model was justifiable. D, whether the acquisition model was justifiable. E, whether due process was undertaken to mitigate the risks inherent in the procurement process, especially the procurement of such a magnitude. And F, whether due process was undertaken to ensure the affordability of the equipment. In dealing with the questions raised in paragraph 6 above, we have taken into account that from inception to the eventual implementation of the SDPPs, various administrative and executive decisions were taken. It is therefore apposite to deal with the question whether the decisions made throughout the SDP procurement process until implementation met the rationality test. In inquiring into the rationale of the SDPPs, it is imperative that the Constitution of the Republic of South Africa, Act 200 of 1993, that is the interim constitution, be considered as it applied at the conception phase of the SDPPs. As it will appear more fully hereunder, the mandate for the acquisition for armaments was further amplified in the Constitution. We submit that in considering the rationale of the SDPPs, it is inescapable for the Commission to take judicial notice of the fact that procurement of this magnitude was novel and unprecedented. The traditional procurement process for armaments by AMSCO, in our view, had to be reconsidered by inter alia, ensuring that the Executive and Parliament had the necessary oversight of the SDP process from conception to the eventual implementation thereof. It is further unavoidable to note that the traditional acquisition process by AMSCO before the advent of the democracy in 1994 was being implemented during the arms embargo and sanctions imposed against the Republic of South Africa. It is for this reason that we also deal with the rationale to deviate from the traditional DOD and AMSCO procurement processes hereunder. The commissioners will also have to take into account the legislative framework available at the time of conceptualization of the SDPPs and that which evolved during the procurement process and implementation phase. At the time of the inception of the SDPPs process, the relevant legislations were the Defence Act, the Armaments Development and Production Act, the Exchequer Act and the Audit Act, and the Interim Constitution. However, during the SDPP process, the Constitution, the Promotion of Administrative Justice Act, the Public Finance Management Act were promulgated. In particular, PAJA was promulgated to give effect to Section 33, 1 and 2 of the Constitution, dealing with the right to administration action that is lawful, reasonable and procedurally fair, while the PFMA inter alia gave effect to Section 217 of the Constitution, requiring organs of state to procure goods and services in accordance with a system which is fair, equitable, transparent, competitive, and cost-effective. Notably, PAJA only came into effect on the 9th day of March 2001, while the PFMA came into effect on the 1st of April 2001. 2000, I beg your pardon, Chair, 2000. This was after the appointment of the suppliers in 1999 and during the signing of the supplier contract and loan agreements in 2000 and 2001, respectively. Now I proceed to deal with the background, Chair. Prior to dealing with the rationale of the decision by the government of the Republic of South Africa to procure armaments, it is apposite to consider the relevant background leading to the justification to the SDPP's decision-making. In particular, it would be inappropriate not to consider the embargo that was imposed against the South African government before the advent of democracy in 1994. In dealing with the conceptualization of the SDPPs, we are mindful of the fact that at the advent of the first democratically elected government of the Republic of South Africa, AMSCO was in the process of procuring military equipment on behalf of the DOD. This acquisition process related in particular to the South African Navy and the South African Air Force. However, during this period, the United Nations Security Council resolutions on arms embargo against South Africa were still in force. We therefore wish to briefly deal with the relevant resolutions of the Security Council as a matter of background leading to the initial decision-making process to acquire armaments. Now, on the arms embargo resolutions of the United Nations Security Council, the Security Council on the 23rd July 1970 adopted the United Nations Security Council Resolution 282, which was intended to consider the effectiveness of the previous Resolution 191 it had adopted on 18th June 1964. The Security Council, in adopting Resolution 282, noted that despite the passing of Resolution 191, which had condemned apartheid and established a group of experts to study the feasibility and effectiveness of measures that could be taken under the Charter, it was concerned by violations of the arms embargo passed against South Africa. The Security Council, in passing Resolution 282, reiterated its total opposition to the policies of apartheid and reaffirmed its previous resolutions on the topic. The Council called upon member states to strengthen the arms embargo by ceasing the provision of military training to members of the South African Armed Forces and by taking appropriate action to give effect to the resolution's measures. However, it appears that Resolution 282 was not effective to ensure compliance by member states, as it was voluntary and not mandatory. On the 4th November 1977, the Security Council unanimously adopted the United Nations Security Council Resolution 418, which imposed a mandatory arms embargo against South Africa. However, as is evident from the evidence and documents before the Commission, the South African government continued to circumvent this embargo in an attempt to strengthen its Navy and Air Force and to sustain its bush war. However, according to Rear Admiral Alan Green, this resolution had a direct impact in the failure by the SADF to procure corvettes from France. Further circumventions by South Africa led the Security Council to pass Resolution 591. On the 28th November 1986, the Security Council unanimously adopted the United Nations Security Council Resolution number 591 after recalling Resolution 418, Resolution 421, Resolution 473, and Resolution 558. The Security Council strengthened the mandatory arms embargo imposed against South Africa by Resolution 418 and made it more comprehensive. Resolution 591 sought to clarify vague terms from the previous resolutions on the topic. Most importantly, the resolution urged member states to ensure that components of embargoed items did not reach South Africa through third countries, including spare parts for aircraft and other military equipment belonging to South Africa, and any items which other countries may feel are destined for use by the South African police force or the military. These items included the aircraft engines or parts, electronic and telecommunications equipment, computers, and four-wheel drive vehicles. You will notice, Chair, that there is emphasis on the four-wheel drive vehicles. This is just to illustrate as to how serious the embargoes went. It went even outside the terrain of strictly a military armament. In terms of arms and related material from Resolution 418, this included nuclear, strategic and conventional weapons, all military and paramilitary police vehicles and equipment, and other related material. The Security Council urged particularly against any cooperation in the nuclear field. The Security Council then went on to urge member states to not receive any imports of arms, ammunition, or military vehicles from South Africa, asking those that had not yet done so to put an end to all exchanges and visits, including by government personnel. It also requested member states and those who are not a member of the United Nations to not participate in any activities in the country that may contribute to South Africa's military capability, ensuring national legislation should reflect this. It was apparent from the evidence of the Department of Defense and AMSCO that some states still cooperated with South Africa. This, in our view, is apparent from the assistance from Israel in the upgrading of the Mirage 3 to a digital cockpit and a few tweaks to create a cheetah aircraft. And what also comes to mind is the attempt by Spain to assist the government of South Africa with regard to the corvettes during the time when the embargo was still in place. Further, Resolution 591 called on the then Secretary General, Javier Perez Cuellar, to report on the progress of the implementation of the current resolution by no later than the 30th day of June 1987. The adoption of Resolution 591 was important to tighten the loopholes left by the previous resolutions. It was clear to the Security Council that the then South African government circumvented the embargo in various ways, which included the procurement of military technology and components which it could not procure openly. As it will appear more fully hereunder, the effect of the embargo and sanctions had an adverse effect on the failure to procure or upgrade equipment for the Navy and the South African Air Force. The aforesaid Security Council resolutions, though circumvented in some instances, had a direct effect on the status of the defense equipment prior to 1994. The embargo was lifted by Resolution 919 following democratic elections in 1994. United Nations Security Council. Yes. On the ability. Thank you, Commissioner. I do agree that that's how it should read, because the aim was to acquire and not to acquire. May I then proceed with paragraph 18 on the same page? The embargo was lifted by Resolution 919 following democratic elections. United Nations Security Council Resolution 919 adopted unanimously on May the 25th, 1994, after recalling all resolutions in South Africa, in particular, the already mentioned resolutions. The Council welcomed the recent general elections and new government and decided under Chapter 7 of the United Nations Charter to terminate the arms embargo and all other restrictions against South Africa. Measures imposed in other resolutions would also be ended. The Committee of the Security Council established in terms of Resolution 421, may I just say, amend to read in terms of Resolution 421 was established. Was also dissolved, I beg your pardon. We submit that Resolution 919 was instrumental in paving the way for the SDPP's procurement, as it will appear more fully hereunder. Now, the background given does actually show that the United Nations Security Council was kept busy over quite a long period of time, just in order to deal with the armament of South Africa under the apartheid regime. Now, I will proceed. As it will appear more fully hereunder, Germany only agreed to participate in the SDP procurement process in relation to the frigates and the submarines after the lifting of the embargo and sanctions against South Africa. We therefore wish to deal with the status of the arms equipment before the SDPPs immediately after the lifting of the arms embargo, which, in our view, is relevant to the question of rationale on the decision to procure the armaments. Now, Chair, the paragraph or the heading, the topic that I'd like now to deal with or relates to the status of arms equipment pre-1994 and the need for armaments. Evidence was led by the witnesses, especially from the Navy, as well as the Air Force, to indicate to this commission the status of armaments at that time, at the advent of the new democracy. I'd like to get just a directive or a direction from the commissioners as to whether it is necessary to read into the record this portion of the evidence, or an indication will be given while or at the appropriate time. The status appears on pages 10 to 27.
And Ms. Ramokhaga, thanks a lot for this information. I think you properly captured the evidence of the various witnesses about the status of the various equipment prior to 1994.
Yes, Chair.
I think it's properly captured.
Yes.
And we are really thankful for that. But I do not think it's necessary for you to read into the record, because various witnesses have already testified about this. There was no controversies when it came to this portion of the evidence.
Thank you, Chair. I also do agree with it. And then with regard to the next topic from pages 27 to 31, deals with the processes undertaken in response to the mandate to acquire the armaments. Those processes would that would address the interim constitution, the final constitution, And then page 31 is the white paper and the defense review. In actual fact, all that up until page 36 deals with what we believe is actually a common cause, and it's something that is not even controversial, because it's just stating the status as to what processes were undertaken, or democratic process that were undertaken, the white paper, the defense review, how it was unanimously adopted by all the stakeholders, and then where the department derived its mandate from to arm itself. Unless the chair directs otherwise, I would like to suggest that we then proceed to page 37, which deals with what really, which deals with the SDPPs being the real cause of the establishment of this commission.
We agree with you. Maybe start on page 37 of your submissions.
Thank you, Chair. Okay. Now, the SDPP process. The SDPP process was formally initiated on the 23rd of September 1997. The new cabinet strategy and tendering actions of September 1997 formally reset the project Citron on the acquisition status in which it had been in 1994 at the start of the project study. Tendering activities of the project study of 1994-1995 RFOs, offers, evaluations, selections, and shortlisting and project study reports were rendered. May I just request that this be read into, there should be some amendment, were rendered null and void by the restart of the processes in terms of the SDPPs. Germany had declined to participate in the tendering process executed prior to the lifting of the sanction. Germany was included when the process was restarted. We have heard from the witnesses. We have heard the witnesses from the Department of Defense that the defense budget during 1980s was at its peak, and in 1990, the budget was severely reduced, and the armaments acquisition was halted in 1991. While a conscious decision had been taken to drastically reduce spending on armaments, the country nevertheless still saw the need to procure arms to give effect to the constitutional obligations imposed on the South African National Defence Force to protect the sovereignty and integrity of the Republic of South Africa. The newly elected democratic government embarked on the exercise of transforming the Defence Force in order to have an integrated and balanced force. The all-inclusive investigation on how to model and equip the Defence Force was embarked upon almost immediately after the new government was elected. At that time, the acquisition process that had been initiated was continuing parallel to the investigation undertaken. During the democratic investigation leading to the compilation of the aforesaid white paper on defense and subsequently the unanimous adoption of the defense review, it became apparent to the democratically elected government that it would be in the interest of the country that the acquisition process that was already in motion be suspended so as to allow the defense review to be concluded. This led to the suspension of the acquisition of the processes that had been undertaken then. The acquisitions in respect of the relevant equipment had gone past the DOD arm of service and were now in the hands of AMSCO, which had the exclusive authority to procure the equipment. Chair, may I just apologize for the manner in which the sentence appears or is captured on the document. The acquisition of the following armament, which had gone past the request for information process and was due to be considered at the request of office level, was suspended in or around 1995 in order to allow the defense review to be completed, which were the LUAs, the submarines, and the corvettes. The outcomes of the defense review confirmed that the armament whose acquisition had been in place was indeed necessary, and further that there was a need to also add some other equipment whose acquisition had not yet been initiated. In response to the defense review and with the intention of complying with the constitutional mandate, the Department of Defense, under its executive head, arrived at a conclusion that the equipment be procured in the form of a package rather than the staggered acquisition as the case previously was. The armament of the South African Air Force and the Navy had reached a critical stage. At the time when the package approach, which later came to be known as the SDPPs, was conceptualized, the Department of Defense had created the Office of the Secretary for Defense, who will be referred to as the ex-SecDef. The SecDef became the accounting officer of the department from 1995. The acquisition unit of the Department of Defense was henceforth located within the SecDef's office. It is just necessary, Chair, that one emphasizes or highlights that this office of the SecDef was established prior to the introduction of the SDPPs. So the SDPPs, upon its coming into existence, ought to take into consideration all the relevant institutions within the Department of Defense and competencies within the Department of Defense. Upon investigation of the procurement process, it became clear that the existing policies were not adequate to facilitate the package acquisition. The executive head of the Department of Defense then promulgated policies that would augment the policies, thus curing the deficiencies. Further, the interim constitution, which was then applicable, advocated for transparency and accountability in respect of procurement. The model created to accommodate transparency and accountability was the acquisition model with a 3-tier evaluation process, being the first to the third orders. The advent of this model meant the introduction of a new dispensation where AMSCO could not be the sole role players with regard to procurement at the project level. Again, Chair, I apologize. In order to ensure that the experiences that the AMSCO personnel had gained over time, AMSCO had presence in all the authorities or institutions that participated in the procurement, from the project study to the final stage of the execution of the acquisition plan. The unanimous adoption of the defense review by Parliament confirmed that the acquisition of the identified armament was necessary as per the recommended design option. Resultantly, the Department of Defense was charged with the responsibility to execute the Defense Review Directive, which sought to implement the mandate of the Constitution interim then. This brings us to the consideration whether the decision to change the acquisition model was rational or not. The evidence before this commission is that the acquisition model prior to 1997 was generally staggered and on an arm of service basis. One illustration of the deliberate staggering of the acquisition was when the Navy decided that the acquisition of the vessels would be structured in such a way that the corvettes would be prioritized over the submarines. Notwithstanding the critical status in which the Navy was in relation to the above equipment, the initial agreement was that the submarines replacement acquisition would only be initiated when the procured corvettes were in the build stage. And we have to be mindful of the fact that at the time, the approach in respect of the corvettes was to procure a newly designed corvette. So the plan was that the design should be approved, and then when the corvettes are in a build stage, the submarines procurement would then kick in, because the submarines that were to be procured would be the existing armament. It is also important to highlight that the traditional acquisition model in place then was the contract with multiple suppliers in respect of the same equipment. This should be considered, bearing in mind that there were, at the time when the acquisition model, the traditional acquisition model was used, there were also problems of the embargoes and so forth. Hence, the approach would be that, okay, let's contract, let's scout around, get a piece of this there, a piece of this there, and a piece of this there. This meant that the department would procure different suppliers, would procure from, I beg your pardon, Chair, different suppliers and conclude separate contracts with separate suppliers. The Minister of Defense ushered in a novel approach in respect of the above for the acquisition of the armaments in compliance with the Defense Review Directive. The acquisition philosophy shifted from the multi-contract for one equipment to, may I just rephrase this? The philosophy shifted from the multi-contract for one equipment to one contract for one equipment. So it shifted from multi to one to one to one. In considering the rationality in respect of change of the acquisition model, the following facts should also be taken into consideration. South Africa was facing block obsolescence in respect of an equipment which was of cardinal nature. Thus, the country desperately and urgently needed the equipment. This means that if the same model of multi-contractors per equipment would be implemented, the acquisition process would be onerous to the department with the acquisition of this magnitude. The long overdue equipment acquisition could not be deferred any longer. The practicality of the arm of service approach in the given circumstances would also have to be considered. The statutory position of the Secretary for Defense was in place, and the acquisition unit had been established within the SecDef office. This being a statutory imperative of the SecDef. The Constitution and the Defense Act advocated for transparency and accountability. Now, bearing in mind that these are the factors that were also taken into consideration, the minister then decided to introduce the package acquisition model. The evidence before the commission is that the traditional acquisition processes were not adequate to execute this novel approach. The minister then issued directives to deal with the deficiencies in the existing policies. The directives, which introduced new elements to the existing model, are described by witnesses as deviations. In order to assist in the determination whether the decision to introduce new policies in respect of the acquisition was rational or not, the phased-in policies will be interrogated in the context of the challenges that the old policies posed, if any. and the impact of the new directives on the principles of transparency and accountability. These considerations are based on the evidence of those who supported the procurement as well as those who were against the procurement. In considering whether the acquisition process introduced, and may I just indicate to the Commission before I proceed to the next paragraph, to say, when we say the evidence of those who supported and those who did not support, I'd like to mention that most of those who did not support opted not to give evidence before this Commission. However, consideration was nevertheless made of the representations that were made by them as against the evidence that has been led before this Commission. In considering whether the acquisition process introduced for the SDPP acquisition was rational or not, the process that was instituted and followed must be interrogated. From the evidence before the Commission, the SDPP acquisition was based on two models. The first one being the traditional one until the completion of the RFI phase, and the second one being the SDPP phase, which effectively endorsed the traditional process undertaken up to before the RFI phase and nullified the RFI process that had been undertaken. The new RFIs containing the new elements identified for the SDP purpose was issued. The acquisition was thus done through the fusion of the two processes. Now, from the evidence before the Commission, the SDPPs did not come in to displace the existing procurement process. It came in to fill the gaps or cure the deficiencies or the challenges that could stand in the way of the SDPP approach being a new approach. Now, the traditional procurement processes followed prior to the SDPP were not informed by a constitutional framework, but were used as a means to circumvent the United Nations resolutions, and in our view, could not have met the post-apartheid constitutional requirements of transparent, competitive, and cost-effective tender process. However, before we can deal with the rationality or otherwise of the SDPP tender process, it is apposite to give an overview of the pre-SDP procurement process for the armament. Now, Chair, from pages 43 to 46, we are just outlining we are just giving a brief synopsis of the traditional acquisition, the steps that were followed in the acquisition process, and this is not controversial. If the Chair agrees, then I would beg leave to commence on page 45 with paragraph 111. May I proceed? Thank you.
Whether, paragraph traditional acquisition process on page 43, whether those paragraphs through to the SDPP process, through to just a minute. I think there are quite a lot of pages dealing with aspects that I do not think fall within your term of reference rationale. And there's also dealing also with financing on page 56. You've got amendment of the RFO, request for offers relating to the NIP, etc. I just wonder whether these fall within the term of reference dealing with rationale. Then you deal also with national industrial participation policy and so on and so on. Maybe up to page 63, I would perhaps understand when you deal with the affordability of the SDPP on page 62 onwards. But I think between page 43 and page 62, I doubt whether those fall within your term of reference rationale and whether it's necessary really to go through them. I'm just wondering.
Commissioner Musi, it is our submission that the best way to deal with information that will assist this commission to arrive at a conclusion whether the acquisition was rational or not, as I have stated right in the beginning, is that we need to interrogate the processes that were undertaken. And these processes were undertaken in an environment where, or they led to criticism being leveled against this model. And the main criticism that we are focusing on is the criticism that is actually described as deviations in the deviations from the traditional acquisition model to the SDPP acquisition model. Now, Mr. Chrysel and Mr. Captain Jordan led evidence about the processes.
Okay, Ms. Lomaka, I think you can continue.
Thank you, Chair. In order to save time then, I will proceed to page 47, which deals with the deviations. The model is criticized mainly because there is an assertion that there were deviations, but the question is, were the deviations rational or not? And I will proceed from paragraph 116. The main thrust of the criticism of the above policy is that there was interference with the AMSCO process, and further that AMSCO was divested of its acquisition powers as a result of the three order institutions that were put in place to carry out the functions that had all along been discharged by AMSCO exclusively. The cause of complaint is that the DOD Directive 4 of 147 had the effect of implementing the process that fell outside the existing AMSCO and the DOD directives. The main thrust of the criticism of the above policy is that there was interference with AMSCO processes, and further that AMSCO was divested. Well, I then proceed to paragraph 118. Criticism against the processes relate to the process within the AMSCO environment. This is so because the interruption of the procurement process happened after the DOD process had been concluded. The witnesses highlighted the following deviations. In the SDPP process, the guidelines were used in the development of value system and RFOs, but there were deviations in respect of the responsibilities of the AMSCO program manager and project teams. The practice dictates that the process would be led by AMSCO and only provides for participation by the DOD on the evaluation panels. In the SDPP process, some of the value systems and evaluation reports were finally approved and signed off by the DOD and not AMSCO. Now, with regard to this criticism, we cannot take it further because Mr. Crisel, who alluded to this, indicated that he just stated that some of the evaluation value systems were finally approved by the DOD and AMSCO. No evidence was led to just indicate to this commission as to which those were. He mentions that it seems it related to some weather corvettes or submarines, but there was no evidence to support this, so we could not interrogate this criticism further. Now I proceed to deal with the next criticism. The decision-making powers and delegations within AMSCO were described in this document. The AMSCO Board of Directors being the tender board, the sole authority that can authorize preferred bidders and also authorize the contract to be placed in identified preferred bidders. In the case of the SDPPs, the preferred bidders were eventually authorized by Cabinet, and subsequent contract placement was also authorized by Cabinet. This is common because this was as a result of the three-tier model that was established. Now, in paragraph 121, the cause of complaint is that the SDP process deviated from the normal AMSCO process in the sense that the AMSCO would not solicit RFOs from prospective bidders if funding had not been budgeted for, and AMSCO would also not enter into negotiations with a preferred bidder if a budget ceiling had not been established. Now, the criticism relating to the finances, including the budget and the budget ceiling, should be assessed bearing in mind that the Department of Finance was also involved in the process at all material times from the beginning to the end. This approach illustrates the appreciation of the fact that this being a massive acquisition, it would have a serious impact on the economy of the country. Hence, the involvement of the Department of Defense, the Department of Finance, which unfortunately is also falls also under the criticism leveled against the SDPP approach. The Constitution of SOFCOM did not provide for a decision-making authority in respect of any matters that would materially affect the evaluation as it pertained to the selection of the preferred bidder. However, SOFCOM was entitled to submit recommendations to the COD. The Minister of Defense had approved this deviation from the standard AMSCO procurement procedures through the appropriate structure. That is the evidence before the Commission that he actually had obtained the change or the authority to change the approval structures through the correct institutions or authorized bodies. In this case, the witness submits that Minister of Defense had approved this deviation from the standard AMSCO procurement procedures through the appropriate structures. There is no suggestion that the minister acted improperly. The concern seems to be, why does the minister flood the AMSCO terrain with non-AMSCO officials? The answer to this is found in the advocacy for transparency and broad representativity in respect of a massive acquisition of this nature. Now, the evaluation results indicated preferred bidders that were presented to the AASB, AAAC, and the Ministers' Committee, and subsequently the Cabinet for approval, were all presentations. Now, the answer to this, in respect of this element of the so-called deviation, the question is about how information was presented. And the answer to that is that this criticism goes to the style of communication. The authority for a particular style of information sharing was not presented before the Commission. As a result, this point cannot be taken any further. The previous paragraph.
Say that in this case, the witness submits that the Minister of Defense had approved this deviation, etc., etc. Which witness are you referring to?
Thank you, Commissioner Musi. The witness that I am talking about is Mr. Chrysel. May I then proceed? Now, the next criticism is that the evaluation results of the DIP and NIP evaluation teams were moderated jointly by the DOD and the DTI. The cause of complaint seems to be that AMSCO was excluded from moderating the DIP proposals. The reality is that there were now 3 distinct areas of evaluation, with the industrial participation split into 2. Who operated in silos, that is, the teams operated in silos, to avoid or minimize the risk of information sharing. What is important is that the user on his input, or rather, what is important is that the user was also formed part of the moderation, the user being the better person vested with the power to determine as to what value can the NIPs add. What also is the subject of criticism is the integration of the DIP and the NIP. The DTI was involved in the evaluation of the NIP proposal, and a team comprising of from the DOD and AMSCO was responsible for the DIP proposals. Now, the response to this criticism is that let me just find that. I'm trying to shorten this thing. Is found in the evidence that was presented, I think, by Dr. Rastom G, who gave full background and history of the development of the counter trade, as well as Mr. Vanan Pillay, who also gave evidence regarding the NIPs and the implementation. Now, the brief of this team is not deal with the nitty-gritties of the industrial participation within the DTI environment, or any environment for that matter. But the brief of this team is to look at the rationality of any elements that were introduced specifically through the SDP, and seeing that the introduction of the industrial participation is also subject of the criticism. The team deemed it appropriate to deal with this aspect in its submissions. And I would like to inquire from the Commission as to whether we should proceed to read the information into the record. It is the information relating to the NIPS is slightly long, but it is important because it highlights the fact that at the time when the SDPP came into existence, there was already formal policy within the Department of Trade and Industry that the industrial policy should be implemented. There is also history of the fact that even prior to the formal adoption of the IP within the Department of Trade and Industry, there had already been cases where large acquisitions were actually rejected or cancelled because of the fact that the national industrial participation had not been factored in. The examples being the Corvettes, the attempted acquisition of the Corvettes, as well as the attempted acquisitions of the Boeings. With specific reference to the Corvettes, the cabinet actually, when it rejected that prior to the adoption of the policy, directed AMSCO to go and factor in the industrial participation. The decision as to whether this portion of the evidence should, or of the submission should be read into the record, from the record, should be read into the record or not, is a determination that the commissioners, the chair, can make.
Ms. Lamachar, thanks a lot. You have given us the information. I think there has been enough evidence dealing with the NIPS. I think there were almost 8-9 witnesses from DTI which dealt with with the NIPS. We'll be satisfied if we don't read this into the record. Thank you.
Thank you, Chair. You will notice at the end of this presentation that our submission is that the approach was rational, and that would also include the NIPS, or as appears on the submissions. May I then proceed to the next topic? It's the criticism of the introduction of the IONT into the system. Now, the IONT, we are dealing with it from page 53 onwards. Now, under the topic IONT, we are dealing with the scope of the IONT. We then proceed to deal with the committees that were set up in order to make the work of the IONT easier. We also deal with the fact that the IONT, upon its establishment, realized that there's a need to beef up its competencies. Hence, it then required the assistance of the experts from the financial as well as the legal fraternity. that information, we believe, is actually common cause. What maybe we should look at is, because the rationality of the introduction of the IONT is also on the spot. What we have done has been to look at the work of the IONT and say, can we say that the manner in which they executed their mandate was rational or not? Now, I'd like to take the Commission directly to the issue of the amendment of the policy, the industrial participation policy in particular, relating to sizing down the number of elements or variables in respect of which the national industrial participation could apply or not. The reason why I'd like to take the commissioners directly to that is that at the time when Mr. Jayendra Naidu was leading evidence on behalf of the IONT, both commissioners raised a question as to whether the IONT was a policy-making forum. And there was an engagement between the commissioners and myself as the evidence leader. At the end, that subject was left on the agreement that it would have to be addressed later, not at that stage. Now, I am not sure as to whether that question is still bothering the commissioners or not. So I will just deal with it shortly and proceed to other areas. One of the outcomes, should I read it into the record? One of the outcomes of the negotiations by the IONT is that the variables that would be recognized for the SDPP process within the industrial participation environment of the DTI was that the variables were trimmed down from 9 to 3. So the only elements that would be considered would be sales, exports, and investment. And what they did was to also introduce the element of eliminating the multipliers in respect of the three elements. It is on record that prior to then, or rather, the policy that is in place is that in respect of exports as well as investments, there are multipliers factored in, giving 2 credits to 1. Now, what they did was to say, no, and the agreement that they managed to get was that the weighing or the scoring would be 1 to 1. The elements considered would only be 3. Now, in order to answer the question that was asked by the commissioners as to whether IONT was the policy-making forum or not, we have to bear in mind that Mr. Jayendra Naidu's evidence is that they were just an institution that was there to assist cabinet. They would make recommendations, not even directly to the cabinet. They would make recommendations to the ministerial cabinet committee that was established specifically for the SDPP purposes. Now, with the consent of the ministerial committee, they were able to negotiate with the suppliers and agree about these changes. And they placed the changes in the hands of the ministerial committee to then consider. The ministerial committee, having full details relating to these changes, then tabled a presentation through Mr. Jayendra Naidu, talking to the issue of the amendment. And that is how the amendment was then adopted by cabinet. So the IONT at no point ever rose to a level where it could make policies or amend policies. Now, this amendment was effected by the very cabinet that had approved the existing national policy on industrial participation. We should be mindful of the fact that, Chair, this was actually a special amendment. It can't be said that it was an outright amendment. It was a special amendment procured by an authorized institution set up by the cabinet. And we say it's a special amendment because this amendment was done solely for the purpose of the SDPP and nothing else. And that industrial policy, industrial participation policy within the Department of Trade and Industry continues to be implemented in the manner in which it was for the rest of the acquisition that fall within the threshold for which it was set. Unless there is still anything that bothers the commissioners about that point, I would like to pass.
Well, thank you. I think we can pass. We are comfortable about that.
Okay. Thank you, Chair. You will see from the, let me just see, from the submissions that we have dealt fully with all the outcomes of the what do you call it? The IONT negotiation exercise. There is an issue that seems to also have been bothering some of those that criticize the acquisition, and that is the issue of the acquisition of the Hawks and Gripens, while the cheetah's lifespan was due to expire in or around 2012. That also is taken care of in the submissions. Unless there's a point that the chairs would like to take me to take them through, I will do so. But what is actually a common cause from the evidence by the users is that the three-tier system that had been in place even at the time of the SDPP acquisition process was seen to be the model to be continued with. So a suggestion that there was at some point, especially relating to the acquisition process of the SDPPs, where the South African Air Force was on any other system other than the three-tier system, will not be correct. So it was just to continue with the system that was in place. Chair, may I just turn to page? Now I'm losing direction. Now, just before I get off the IONT evidence, I'd like to take the commissioners to page 61 of the submissions. And in page 61, what I would like to draw the attention of the commissioners to is that paragraph that deals with the origin of the promises of about 65,000 jobs. Now, the evidence that was led by Dr. Rastomji is that at the time when the Minister of Defense made a statement, the announcement of the possible the creation of possibly 65,000 jobs, that statement was made based on what had been presented before the minister by the Department of Trade and Industry. And the Department of Industry, when it made the projected figures that, when it gave the projected figures that it gave, it was relying on the information that had been sourced from the RFOs at the bidding time. And remember, Chair, maybe it's time to talk about even this thing of the NIPs, to say the NIPs up to the time of the negotiations by the IONT, they were scored on 9 elements, which included jobs. But at the time when the acquisition was finalized, the only elements on which the NIP could be scored was in relation to 3, which excluded jobs. So at the time when the minister made a statement of promises of about 65,000 jobs, it was at the time when the elements included jobs, and jobs were taken into consideration by the Department of Trade and Industry. If there are any questions on that point, I will deal with them. Otherwise, I beg leave to then proceed.
Ms. Lamaha, how long do you think you're still going to be busy?
30 minutes.
You know, your submissions are quite comprehensive. We have received them. We have gone through them. And maybe I would suggest that we'll break for tea. When we come back for tea, touch on those areas which you think are very critical. We have already gone through them. Because, you know, yesterday we received them yesterday, and we did get time to go through them. So we are going to adjourn for 20 minutes, and when we come back, just try and deal with those areas which you think they are very, very important. Because fortunately, we do have your submissions, because we need to get to Dr. Young's evidence now.
Thank you, Chair.
I mean submissions, not evidence.
We'll do so. We will trim down, Chair. Thank you.
Thank you. Then let's adjourn for about 20 minutes or so. Thank you.
because then my view is you are now in the realm of contractual arrangements. Yeah. So, Judge Musi says, "Man, how little translated, that's what it means, right?
Thank you, Chair. We have had the opportunity to look at how we present the submissions moving forward. The next topic that we are supposed to deal with is the affordability, which appears on pages 62 to 76 of the written submissions. Now, with regards to the affordability, we would just like to highlight that the criticism arising from the comparisons between the bread and butter issue and the bullet are fully addressed in our submissions, and also the main issue of affordability, especially in relation to the budget, is also dealt with, we believe, adequately in our submissions. We can just highlight that the evidence before this commission is that the budget did not just suddenly balloon. The budget remained within the norm, except for, of course, the later years when there were problems of the economic meltdown. The next topic would be the Ministerial Cabinet Committee that appears on 76 pages 76 to 79. The evidence before the Commission is that the Ministerial Cabinet Committee was actually the bridge between the Cabinet and all the other stakeholders. What is important about even the Ministerial Committee is that the Ministerial Committee would also make recommendations to the Cabinet for the Cabinet to decide. So at no point where was the Ministerial Committee vested with the power to decide and displace the Cabinet. Now, the next topic then is the analysis, which appears on pages 79 to 88. And then it's the criticism from pages 88 onwards. Where is that one? 119. Now, we'd like to then proceed to close by dealing with the submissions. The legal framework or legal authorities that we rely on for reaching conclusions do appear in the submissions, and even the issues of rationality in terms of the common law and the statute are fully addressed in the submissions, unless there is any particular point that the chair would like us to address him about. I propose that we proceed to page 119, which deals with the submissions from paragraph 310. It's a few pages, Chair. One can read that into the record quickly. If it pleases the commissioners, may I proceed? Thank you. We submit that the SDPP process was not a perfect process and was here and there bedeviled by inaccuracies. However, that does not take away the fact that the process followed as informed by the pressing need to acquire armament is fulfilling the said constitutional obligations mentioned here above was rational. Similarly, in the PEPCO case, the judge held that recognition of material mistake of fact as a potential ground of review obviously has its dangers. It should not be permitted to be misused in such a way as to blur, far less eliminate the fundamental distinction in our law between two distinct forms of relief: appeal and review. And I proceed to the sections that are highlighted. It would not be possible to review and set aside its decision merely because the reviewing court considers that the functionary was mistaken, either in its assessment of what facts were relevant or in concluding that the facts exist. If it were, there would be no point in preserving the time-honored and socially necessary separate and distinct forms of relief which the remedies of appeal and review provide. The ultimate question in a review of administrative action is whether the decision falls within the bounds of reasonableness. It does not appear that the government officials failed to meet the test when consideration is taken on the novelty of the SDPPs, the funding thereof, and the procurement process that followed. Important in the context of the present inquiry is the requirement of prejudice. The question is whether the public or any person will be able to raise prejudice on the procurement of the armaments. Mr. Donaldson and Mr. Manuel were able to show that the overall expenditure on social and development issues, in brackets, the bread and butter, were not affected by the procurement of the SDPP equipment. This also includes the budget deficit, which at one time had a surplus. According to Mr. Manuel, the defense budget is still below the international norm at about 1.5% of the GDP. General Shoke, the chief of the South African National Defense Force, has testified on the overall benefits in the use of the current equipment and that, in fact, more is needed. Where in administrative law, a decision maker relies on both permissible and impermissible reasons for acting, Baxter, administrative law is the authority, at 521 postulates the following review test. It is submitted that the test might be better formulated in the following way. Would the authority, had it not been actuated by bad reason or reasons, have reached and been legally entitled to reach the same decision upon the basis of the remaining permissible reasons? The question is hypothetical and its answer involves some speculation. Nevertheless, by characterizing it in this way, the public authority is not penalized for insignificant errors when it would have reached the same decision anyway. If permissible reasons for the decision exist and they would still have dictated the decision, no prejudice has been suffered. The approach advocated by Baxter accords with the approach adopted in the event of a finding of a gross irregularity on review. And we refer to the case of SA Veterinary Council. At paragraph 40, it was held that in such circumstances, the proceedings can be saved if it is apparent that despite the irregularity, the applicant was not prejudiced because the finding would have been the same if the correct approach had been applied. It is further apposite to mention that the allegations made by Crawford Brown against Mr. Manuel and the SDPP procurement were the subject matter of the court in the Eka case. We submit that the court had the opportunity to consider the rationality or otherwise of matters relating to the SDPPs. In particular, the following findings of the court are worth noting. At paragraph 46 thereof, applicant's charge of irrationality is squarely based upon the existence of the warnings contained in the affordability report. These warnings must, however, be read in the context of the document as a whole. They are contained in a report which purported to provide advice to government in regard to affordability of the proposed acquisition. The object of the warnings in the report is to bring possible negative consequences of the decision to the attention of the decision maker. The thrust of the warning is not to advise the decision maker to desist from concluding the transaction in question. The real thrust is to inform the decision maker what risks to take into account if he proceeds with entering into the loan agreements. Other elements of the report are quite positive. For example, the comments on the method of financing referred to in paragraph 24 above. It is relevant furthermore that the affordability report, in brackets with the warnings of course, was before a cabinet when it took the decision to acquire the arms in question. It must be accepted, therefore, that cabinet approved the acquisition with full knowledge of the warnings. In this case, second respondent said that he did apply his mind to the affordability report, including the warnings. It is tried law that the test on review is not whether the court agrees or disagrees with the decision in question. The question, when rationality is the yardstick, is whether the decision is so irrational that no rational person would have taken it. By mainly focusing on the warnings, applicants have not established such irrationality in this case. I am accordingly of the view that there is no merit in the review of the warnings. We submit that the basis of the findings in ECA Supra will find application in respect of the rationality of the decisions taken by the government from the formulation of the white paper to the decision of the cabinet to purchase the SDPP equipment. In particular, after Mr. Brown and his co-applicants' application for leave to appeal was dismissed by the High Court, the Supreme Court of Appeal and the Constitutional Court on the 17th day of May 2004, 18 August 2004 and 3 December 2004 respectively. There is no basis, in our view, for the commissioners to find that the SDPP process did not meet the rationality test. However, even if there may have been a material irregularity, still, that does not justify the cancellation of the SDPP agreements. In particular, noting the period of time that has elapsed since the acquisition of the equipment. In fact, the commissioners can take judicial notice that the Department of Defense is currently busy with another defense review. It is appropriate to mention the remarks of Scott J.A. in Chairperson Standing Tender Committee and others' case. And I quote, "In appropriate circumstances, a court will decline in the exercise of its discretion to set aside an invalid administrative act, as was observed in the Udekral Estates case. It is that discretion that accords to judicial review its essential and pivotal role in administrative law, for it constitutes the indispensable moderating tool for avoiding or minimizing injustice when legality and certainty collide. Under the rubric of the second, I would add considerations of pragmatism and practicality. In my view, the circumstances of the present case, as outlined above, are such that it falls within the category of those cases where, by reason of the effluxion of time, in brackets, and intervening events, and invalid administrative act must be permitted to stand." Close quote. Conclusion and recommendations. We noted that some of the witnesses who have written extensively on the SDPP process and its alleged irregularities, despite having made written submissions to the Commission, declined an invitation to give oral evidence. However, we submit that on the basis of available evidence, both documentary and oral, there is no justification to make a finding that the SDPP process was irrational. That concludes our submissions, and thank you, Commissioners.
Ms. Ramachara, thanks a lot for the submissions. They're quite extensive, and I'm sure they're going to be helpful to us when we prepare our report. Thank you.
Thank you, Chair. I believe there's the next person to present the submissions will be Mr. Dr. Young. I'm sorry.
You are right. You are right. I think you are done. You are done. The next person is Dr. Young, who is going to make submissions. I'm not sure, Dr. Young, whether you want a 5 minutes adjournment to arrange your things, or are you in a position to kick off straight away?
No, Chairman, I need as much time as I get, so I'll use those 5 minutes. Sorry, no. I just wanted to say I certainly would like to start now, and I am in the process of changing my flight from 6:15 this evening until 9 o'clock, so that first of all, not to give me extra time, but hopefully I won't put myself under pressure. But also it should give enough time as well for the DOD to start their submissions as well.
Dr. Young, I didn't quite follow. Are you saying you start now, or you are going to require 5 minutes or so to arrange your things?
No, I'm quite happy to start now if you'd like to. The main point I just want to make is I think I was the limiting factor. I live in Cape Town, and I didn't want anybody to think that there's undue time pressure because of me, and I've subsequently changed my flight to much later this evening. So I can be here until 6 o'clock this evening. So I just wanted to make that point.
Maybe, yeah, I understand you can be here until 6 o'clock, but my fellow commissioner told me during the tea break that he's not prepared to be here until 6 o'clock. So we might have to adjourn much earlier than 6 o'clock.
That's fine by me, sir. Okay, I've been listening to three teams of evidence leaders since yesterday, and of course I have had to take my cue from what I've heard. I probably have to state that I'm not experienced in giving argument whether it's in court or a quasi-judicial proceedings like this, but what I'm going about the basis of my oral submissions are also going to be slightly different to what I've prepared in the last 2 or 3 days, partly because of what I've learned in the last couple of days. But my understanding was that all the parties, evidence leaders and interested parties, would prepare written submissions, and then there would be supplementary written submissions, and effectively that would be like the founding, and then the answering, and then the replying. And oral submissions would mainly be in terms of reply, but that doesn't seem to be what I've heard so much. So what my oral submissions are going to be is a brief introduction of my written submissions, but not too much of that, and then a kind of answering statements based on the written submissions that I received from the other parties, and that will be the bulk of my my oral representations or submissions. Of course, I'm not quite sure how one's meant to handle replying statements, but be that as it may, for the moment. By way of introduction, of course, I was subpoenaed, summoned to the Commission as a...
I'm sorry, Dr. Young, if you don't mind, can I help you? I think the first 8 pages, these are not submissions. You're dealing with the background of how you came here, what treatment you hear from the evidence leader, how you discuss with the evidence leader. The purpose of the exercise today is to analyze the evidence and make presentations, in other words, telling us how, in your view, we should write our report. Not to start with the history of how you started with the first evidence leaders. I've looked at this statement. The first 8 pages seems to deal with that. But then I think where you start making submissions relating to the evidence that has been presented, you start on page 9. If you don't mind, we have seen the first 8 pages. Do you mind to go straight to page 9 where you deal with your evidence? Because the first few pages are not dealing with your evidence. You're telling us how you were contacted by the evidence leaders, where you consulted with them, how many times, and so on. That is on record already.
With
Can I
respect,
suggest that, we have this talk, we have these first few 8 pages. You start with page 9, because page 9 is where we deal with the crux of what we are supposed to be doing today.
with respect, Chairman, I wasn't going to address that at all in my oral submissions, at all, nothing whatsoever, but that was relevant as an introduction to my initial written submissions. So I wasn't even starting off on that point at all. What I by way of introduction to my oral submissions, I did not want to refer to that. I was just going to say where my evidence came from, and put it in the context of my my responses to the written submissions of the other parties. Specifically, the most important one from the outset, of course, is those of the Department of Defense. Okay. Basically, what I want to say, I was just by half a sentence say I was subpoenaed as a witness, and I gave extensive evidence in March. It consisted of 237 pages of witness statement. It included about 7,500 pages of documents in the evidence bundles. In terms of these submissions, of course, it starts off with written submissions, which are, of course, quite new, and I will only be addressing those very briefly by way of summary, just as the other evidence leaders have done. They've primarily concentrated on the initial written submissions and not as answers and replies. But it consists of 2 written submissions, a 70-page document which I submitted to the Commission last Thursday, as well as an 11-page response to a specific request from the Commission in response to Bowman Gilfillan's letter to the Commission, copied to me, inviting me to make responses. So that basically my written submissions consist of amalgam of those. I'm saying this in the context of what I'm going to be addressing in answer, using the correct legal term, hopefully, to my response to the DOD's and other parties' written submissions thus far. But effectively, my written evidence from my appearances in March culminated in 8 days of evidence in chief and 4 days of cross-examination. Why I'm saying that, it was very comprehensive. Okay. All of that was backed up by 15,000 pages of formally not only discovered documents, but produced documents to the Commission. And my understanding of the law, and of course I'm only an engineer and not a lawyer, is that written evidence, certainly in the evidence bundles, I'm not quite sure about documents produced for the Commission, is also evidence produced for the Commission. So I'm just saying in terms of the totality of my evidence, what it encompasses. I'm going to be addressing a number of different themes, just as I did in my initial evidence in March. But maybe by way of, in terms of answer, it is appropriate to start off specifically if I'm going to be addressing mainly the Department of Defence's submissions, by the way that they have addressed my own initial evidence in March. They've used the terms...
I'm sorry, Dr. Young. Let me try and understand what how do you want to approach your oral submissions. Are you going to deal with the written submissions that you have given us, or are you going to deal only with what you call a reply to DOD's written submissions? Because if you're going to deal with both, I was going to suggest that maybe first deal with the statement, lunchtime, ask them to make us copies of what you call your reply to DOD's submission. It will be much easier for us to follow if we do have copies of your reply.
Sorry, Chair. Unfortunately, I need to make the observation that that is clearly impossible. We have all, at this stage, submitted initial written submissions, and my understanding is that then there would be effectively answering submissions, which is effectively going to be the bulk of my oral submissions today. So my initial written submissions of, as I said, 81 pages, they are self-standing as my initial written submissions, and most of my responses today are going to be a brief, not a comprehensive, line by line analysis of the written submissions of, effectively, can one call it of my opponents, and I don't have written supplementary submissions for that. That's what I'm dealing with here in oral evidence.
I was just trying to establish you don't have any written reply. You're going to read from your notes or from your computer.
Yes, exactly, Commissioner. I have the DOD's and other parties' written responses, and I've made notes on those. Just remember, to put in perspective, I only got those late on, the first tranche very late on Friday afternoon, the second tranche at 2 o'clock on Saturday morning. So it's absolutely impossible that I could have produced supplementary written submissions in answer to those. So I've made notes, I've made written notes, I've made notes on my computer, and if I may, from my own perspective, is actually make the statement that my submissions here are more advanced than some of them that I've heard for the last 2 days, because I'm not going to be traversing in great detail what is already in writing. I'm basically going to be responding to other parties' written submissions. And if one thinks about it, that, if we were only dealing with our own initial written submissions, when would we get the opportunity of providing answering submissions and especially replying submissions? That can't possibly happen in the timescales that I've heard, between now and next Tuesday. I don't see an opportunity of us coming back here or providing other written submissions. So I intend to deal with that in the time that I have today.
Can I just get one clarity? You are comfortable that we have read your written submissions and you're not going to go through that. Instead, you are going to focus on your replying submissions. Is that correct?
Well, you use the word comfortable. I'm trying to be pragmatic. Of course, I'd be far more comfortable if I addressed all of my 81 pages of written submissions in great detail. But I don't think that is necessary and not a maximization of the use of time sitting here before you. I think I actually heard the chairman in response to Attorney Ramachachas. We've read the written submissions, and certainly I would hope that the same would apply to me. They exist. Everybody has them, and you've got them. They stand. I don't think there's anything that I want to change in my. But of course, I didn't say I only exclusively want to do answering. I wanted to summarize just the most important points of my written submissions. Typically in, I won't say 10 minutes, but say 10% of the time that I use. An analysis or summarization of that, especially as an introduction to my answers to the other party's written submissions, if that correctly answers your question.
No, I don't follow what you are trying to say. Are you going to go through your written submissions, or are you going to leave us because you have read them, and you're going to focus on your replying submissions? Which one of the two are you doing? Are you going to first go through your written submissions, or do you leave that in the knowledge that we have read them, and instead you are going to focus on your replying submissions?
I'm only going to be providing a brief summary of my written submissions, brief summary, mainly as an introduction to the context of what I would call not replying, but answering submissions, which I'm doing orally. So I'm not going to going through all 81 pages, line by line. I'm just going to outline the themes thereof, and specifically emphasize important points on which I can hook my answering submissions, which I'm now doing orally.
Thank you.
Okay. I think it is necessary, and this is not to be confrontational, but from what I have adduced for myself in the DOD's written submissions, that my evidence in their summary is characterized by arrogance and dishonesty and the use of words such as pilfering and preposterous. I certainly hope that none of my evidence that I gave in March is characterized by that, and I certainly would like to concentrate on answering those, if one calls them allegations. I think it's typical in argument, certainly in the limited legal experience, is that normally one's legal representative counter those kind of statements in written argument, including written argument for submission in oral arguments. But that is by way of introduction of what I propose to address. In my own view, is that my evidence, my 12 days of evidence in chief and was measured. It was accurate. It's not characterized by any level of dishonesty whatsoever. In fact, even that statement of arrogance and dishonesty are bald. I can't see any evidence of that whatsoever. And of course, interestingly enough, is that use of the words such as pilfered, which is very close to the meaning of larceny, which is something that came up in my cross-examination. I would like to say that as an introductory to my what I'll be covering in coming up. Be that as it may, another very important thing from what I can remember, the instructions to the parties preparing written submissions, is the point of admissibility of documents. And of course, a great period of time in my initial evidence was in respect of the German reports, and I would like to argue the admissibility thereof. Of course, coming up after me as a witness was Colonel Johan de Plooy, and I was, of course, gratified and pleased, of course, that he submitted the copies, exact same German reports. I only got that evidence from Colonel de Plooy's evidence not that long ago at all, but I am unaware that in that particular session of evidence that any rulings were made that those reports were admissible. So in terms of my own argument, the 3 German reports that I ventilated at some degree, specifically the first one, are indeed admissible. Certainly, if not for normal courts of law, but in quasi-judicial proceedings such as this, that they are certainly admissible for a commission of inquiry. Of course, that was covered extremely briefly in Advocate Sabeko's submissions, and of course, I think I would have to agree that it's up to the Commission to interpret my own interpretation of those German reports. I mean, of course, but what I'm asking the Commission to do is to admit those German reports. I don't think it was as contentious, but I also brought up other documentary evidence of a similar nature, and that was in the second session of my evidence in chief, what I call my extended evidence, which was the last week, and there was a gap where I was away in between, and that mainly was in regard of my response to Advocate Fanahlongwane's evidence, and involved equally the issue of British Aerospace and Saab. And there I adduced into evidence at least 9, I think it was, affidavits, not affidavits, transcripts of evidence under oath that emanated from the Serious Fraud Office, as well as a similar number of documents. And I would submit that, certainly for the purpose of this commission, that those documents are equally admissible. I'm not aware of there being any applications from other parties that they should not be admissible. But of course, certainly in terms of the most important part of my evidence, which is corruption, that my evidence stands not only on, but certainly partially on that evidence. So that is something that I'm making in here in submissions. Of course, another very important leg of all of my evidence regarded the responses to the Department of Defence's primary witness, certainly as regarding my own involvement. And of course, they had a lot of important witnesses, but that, in my context at least, the evidence of Rear Admiral J.E.G. Karmerman was particularly relevant, and I have addressed quite his own evidence to a extensive amount in my written submissions, and I also wish to address some of that in my answering submissions. I think when I use the term of baldness, there's so many submissions made by, or averments made by Admiral Karmerman in his own evidence that are simply not only unsupported, but are completely wrong. One has to be very careful, I know, of use of terms like lying. One can make mistakes, but there are so many of them that is, unfortunate. And I've gone through these in my written submissions that are just so outrageous and so wrong and supported by nothing whatsoever, that is an important part of my my oral submissions here. I have heard the term in the context of Admiral Karmerman's evidence that it is stubborn evidence. Unfortunately, it cannot be taken as stubborn, or certainly it can't. Everything that he gave in evidence certainly just can't be accepted as fact based on his say-so. That being said, as I have outlined, or in point form at least, many different points that are just completely wrong. I never had enough time to ventilate or to do detailed research into every bit of evidence that has come up through this commission and allied evidence. But that is just a sample of the things that are completely wrong. Of course, there are many others that are only constitute half-truths and similar. But in my view, where my evidence is in opposing his own, and there hasn't been hardcore, stubborn documentary evidence, then I would submit that my evidence, where I have provided documentary support for my averments or statements, has to actually take precedence over that. I think I need a quick break for water and a gathering of my thoughts. Okay, possibly I need to apologize. Of course, I'm working here from notes. I've tried to put this in a logical way, but it's not as jointed as I would like it to have been. One of the fundamental things related to the German reports and the DoD submissions in the simple writing off of those reports is they state there in their submissions that these submissions and my evidence in that regard is that these were unauthored reports. Okay, it's clearly cannot be the correct. First of all the reports, as we know, they weren't written on the German investigation reports own stationery, because they were written in Word, but they were clearly emanated from the German investigating authorities in Düsseldorf. In my own evidence, I specifically said who the commanding officer, Andreas Bruns, that is my own evidence, and I think that came up in the evidence of Colonel Deploy as well. But a very important thing regarding the actual author of that, which contradicts the submissions of the Department of Defense, is that Colonel Deploy submitted those exact same reports, but he'd obviously got slightly different versions of them, and that is the physical author of that is somebody called, I think it's Lioba Borowski. Is a woman, and she is a detective inspector of the commercial branch of the Düsseldorf police, and in Colonel Johan Deploy's evidence, I'm not quite sure whether he ventilated this in his oral evidence, but certainly in his 2,588 pages of adduced witness bundles, Lioba Borowski's evidence, documentary evidence attributable to her comes up numerous times, but each of those reports comes up as being written by her. It doesn't have her signature on it, but it's certainly got her name on behalf of what at least I can remember the English translation of the detective chief inspector, I think, is. So of course one always writes these documents on behalf of the commanding officer of the unit.
I'm sorry, Dr. Young. I'm not quite sure whether Colonel Deploy told us who the author of those documents was, because if I recall, he could not even tell us where he got those documents from. He said that he might have received them even from you. As he mentioned, there's a possibility that you could have been the one who provided him with those documents.
With respect, Chairman,
can you just respond on that one, whether will that be the correct position or not?
With respect, Chairman, it wasn't the point I was trying to make. In fact, I said I wasn't sure whether this came up.
Dr. Young, I'm not saying there's a point that we're trying to make. This is a question that I'm putting to you. I'm not saying this is the point that you are making.
Yes. What I said is that the documents that were submitted by Colonel Deploy include the 3 reports. Okay. And those 3 reports, the evidence bundles, have the name of the author as Lioba Borowski. So that is not necessarily in his oral evidence, which of course I was not here, but I have read the transcripts, and I certainly know the issue of the reports was ventilated, I think mainly in cross-examination, but that's not the point I was trying to make, is the reports were adduced into evidence and her name appears in the copies of those reports. Okay, if I may carry on, the point of where the source of those German reports is a different point, but I'm glad you remind me. I was going to address that slightly differently, but it certainly is an appropriate point. Is that the DoD's submissions indicate or state that the source of these reports is unknown. Certainly what I can say, and this is not giving evidence, because this was my evidence, that those reports did not come to Colonel Johan Deploy or his Project Bumits-Butera team from me. It is quite clear from the evidence that of Colonel Deploy that they had those reports, or certainly there are strong inferences of them, that they came to him in 2008. My evidence there was I got them in the first quarter of 2010. So it is 100% impossible that the Directorate for Special Operations could have got them from me. Okay. I think I'd be repeating my evidence, which I think is fair, and in terms of oral submissions, that I did not get those, that the DSO did not get those reports from me. I got them independently from different sources. So it would be incorrect for the DOD's evidence or submissions to at least leave the impression that they could have come from me. They did not. The chronology makes that very clear. In terms of Colonel Deploy's other evidence, there is a document submitted by Lioba Borowski, which is a clear communication with the Project Bumi Patera team, which consisted of Advocate Downer and Colonel Deploy. This is in late 2008, where she specifically refers to reports and information that she had supplied the Project Bumi Patera team. Okay, so it is impossible that I could have done this in 2008 when I only came into possession of them in the first quarter of 2010, and certainly Colonel Deploy's evidence, including that under cross-examination, does not provide the slightest inference that they did or could have come from me. I know for a fact that and that was my evidence. It's not I'm not giving evidence that the DSO, in fact, by that had them. By the time I met Colonel Deploy, he was then in contact in the employ of the police, the Director of Priority Crime Investigation Unit, I think it was my evidence that I met him before I became into possession of those German reports. I see it as 2 minutes to 1 o'clock now. It would certainly help me and probably help everybody else if we did have the lunch now, which I won't use for eating lunch, but to possibly align my oral evidence slightly more effectively. So if it suits the commissioners, this might be a good time to break for lunch.
It's 2 minutes to 1. I think let's take a lunch adjournment until 1:30. Can we try and make sure that we start at 1:30? Fortunately, the evidence leaders are not now involved. I'm sure we should be in a position to start exactly on time after lunch. Thank you.